Hello and welcome. In this video, we're going to dive into the essential rules governing parties in a civil action, understanding who can be a plaintiff, who can be a defendant, and how multiple parties can be involved is fundamental to civil procedure. By the end of this lesson, you will be able to identify who can be a party to a lawsuit, differentiate between a real party in interest and a representative, and understand the concepts of joining multiple parties. Let's begin by defining the basic roles in any civil case. Our first topic is who can actually be a party in a civil action. The rule states that only specific entities can be parties. These are natural persons, that's you and me, or juridical persons, which are entities like corporations or partnerships, or other entities specifically authorized by law. This means you can't sue an idea or a thing. You must sue a legally recognized entity. The term plaintiff is not always the original person who filed the case. It can also refer to anyone making a claim in the lawsuit, such as a counterclaimant or a third-party plaintiff. A counterclaimant, for instance, is a defendant who files a claim back against the plaintiff. Similarly, a defendant is anyone defending against a claim, whether they're the original defendant or a cross-defendant defending against another defendant's claim. So, to recap, parties must be legal persons, either natural or juridical. A plaintiff is anyone claiming relief, and a defendant is anyone defending against a claim. This broadened definition is important as a case progresses. Next, let's explore Section 2, Parties in Interest. This introduces a crucial concept, the real party in interest. The rule states that an action must be prosecuted and defended in the name of the real party in interest. So, who is that? The real party in interest is the one who will actually feel the effects of the court's decision, either by receiving a benefit or suffering a loss. For example, the person who signed a contract and was wronged is the real party in interest in a breach of contract case. Now, let's consider a scenario. Imagine John sells his car to Mary on credit. A month later, Mary defaults on her payments. John decides to sue Mary, but instead of using his own name, he asks his friend Tom to file the lawsuit. Can Tom sue Mary? No, Tom cannot sue Mary. He is not the real party in interest. John, the seller, is the one who will be injured by Mary's breach of contract. Tom has no direct claim. Every action must be brought by the real party in interest, or else the case can be dismissed. This rule exists to protect the defendant. It prevents being sued by a random person, and ensures that the final judgment will resolve the dispute for the party who actually has the legal right. Let's quickly recap. The real party in interest is the true stakeholder in the lawsuit. They are the one who has the legal right to enforce the claim or to defend against it. This rule ensures fairness and efficiency. While the general rule is that the real party in interest must be named, Section 3 provides for an exception: representatives as parties. This section allows an action to be prosecuted or defended by a representative on behalf of someone else. But there's a key requirement. The rule states that the beneficiary of the representative action must always be included in the title of the case. They are deemed to be the real party in interest, even though someone else is litigating on their behalf. Think of a scenario where a child, Sarah, is involved in a car accident. She needs medical treatment, and her parents, who have legal custody, need to sue the at-fault driver to recover damages. The action would be titled, Maria Reyes, as guardian of Sarah Reyes, Viti John Doe. Here, Maria is the representative, but Sarah, the minor, is clearly identified as the beneficiary and the real party in interest. This way, everyone knows who the lawsuit is really about. This rule creates a balance. It allows the legal rights of those who cannot litigate on their own, like children or those who are legally incapacitated, to be protected. At the same time, it ensures transparency by clearly identifying the true beneficiary. To recap this section, a representative can sue or be sued for another person. However, the beneficiary must be named in the case title and is considered the real party in interest. This is a vital tool for ensuring access to justice for vulnerable individuals. Sections 4 and 5 address specific types of parties: spouses, minors, and incompetent persons. Section 4 on spouses has a very clear rule. Husband and wife shall sue or be sued jointly, except as provided by law. This means that if a lawsuit involves their marital property or a shared obligation, they must be part of the same legal action. Imagine a married couple, James and Emily, co-signed a car loan and then defaulted. The bank decides to sue. The bank cannot sue James and Emily separately. The rule mandates that they must be sued together as a single entity. The purpose of this rule is to protect the interests of the entire family and to ensure that all parties who are jointly liable or who jointly own property are part of the same legal proceeding. So, to reiterate, Section 4 requires spouses to act together in most lawsuits, reflecting their legal union. Section 5 deals with minors and incompetent persons. It states that they can sue or be sued, but they must have assistance. Who provides this assistance? Typically, it's their father, mother, or legal guardian. If they have none, the court will appoint a guardian ad litem. This rule ensures that minors and those who are legally incompetent, who may not be able to fully understand or protect their own rights, are properly represented in court. A guardian ad litem acts solely for the best interests of the minor or incompetent person in the lawsuit. This rule is not a barrier to seeking justice. Instead, it's a safeguard to ensure fair and informed representation. Now we move to one of the most important concepts for managing complex litigation: Joinder of Parties. We'll start with permissive joinder. The rule here is about efficiency. It allows multiple people to sue together as plaintiffs or to be sued together as defendants if two conditions are met. First, the right to relief must come from the same transaction or series of transactions. Second, there must be a common question of law or fact among all the parties. Let's imagine a scenario. A tour bus carrying 20 tourists crashes. Several tourists are injured. Can they all sue the tour bus company in one lawsuit, or do they each have to file their own separate cases? They can sue together. The first condition is met because their injuries arise from the same transaction, the single bus crash. The second condition is also met as they all share common questions of fact and law. For example, was the bus driver negligent? How was the company responsible? By allowing them to join, the court can hear similar evidence and decide similar legal questions just once, saving a tremendous amount of time and resources for everyone involved. It's about making litigation more streamlined and efficient. While permissive joinder is about efficiency, compulsory joinder is about necessity. Section 7 introduces the concept of indispensable parties. An indispensable party is a party in interest without whom no final determination can be had of an action. In other words, you cannot resolve the case fairly and completely without them. Their rights and interests are so central to the dispute that no judgment can be effective without their inclusion. Let's use a clear example. Suppose you and your sibling, Jane, jointly own a house. You decide to sell the house to a buyer, but Jane, your co-owner, refuses to sign the deed. The buyer then sues you to compel the sale. Can the court order you to sell the house without Jane being a party to the lawsuit? No, it cannot. Jane is an indispensable party. A court order compelling the sale would directly affect her ownership rights. The court cannot issue a judgment that harms her interests without her being part of the case and having the opportunity to present her side. She must be compulsorily joined, either as a plaintiff or a defendant, for the case to proceed. The logic is straightforward. If you can't resolve the case completely and fairly for everyone affected, you shouldn't proceed at all. This protects parties who could be harmed if they weren't given their day in court. So, to recap, indispensable parties are those whose interests are so vital to the case that the action cannot be determined without them. Their joinder is not optional, it's compulsory. Between compulsory and permissive joinder lies the concept of a necessary party. This is where Section 8 and 9 come in. Section 8 defines a necessary party. Unlike an indispensable party, who is absolutely essential, a necessary party is not indispensable. However, they ought to be joined to ensure that complete relief is given to those already parties. In other words, while the case can proceed without them, their absence makes the judgment incomplete or leaves open the possibility of future lawsuits related to the same issue. Let's consider a scenario. Imagine you have a business partner, and together you hired a consultant. Now there's a dispute over the consultant's performance, and you want to sue for breach of contract. But you decide to sue the consultant alone, without including your partner. The court can likely proceed without your partner. You and your partner might have joint and several liability, but the relief might not be complete. For example, the court might only order the consultant to pay you. leaving open the question of your partner's damages and the possibility that they might sue the consultant later, leading to duplicate lawsuits. This leads to Section 9. Section 9 instructs the plaintiff, if they don't join a necessary party, to explain why in the complaint. The court can then order that party to be included. What if the court orders you to join the party, but you refuse? The rule says that failure to comply without a good reason means you waive your claim against that specific party. The important part is that the entire case is not dismissed. The action can still proceed, but the judgment won't affect the necessary party you refuse to include. So, to recap, a necessary party is important but not essential. The court prefers they be included for complete relief, but their absence doesn't stop the case. If they're missing, you have to explain why, and if ordered, you must include them or waive your claim against them. What happens if a party who should be a plaintiff refuses to join? That's what Section 10 on the unwilling co-plaintiff addresses. The rule provides a simple solution. If a party who should be a plaintiff cannot be persuaded to join the lawsuit, they can be made a defendant. The person filing the complaint simply states the reason for this in the pleading. This rule is particularly useful when dealing with necessary parties, like our earlier example with the business partner. Suppose you want to sue the consultant, and your partner is a necessary party, but your partner has no interest in suing and refuses to sign the complaint as a plaintiff. Instead of being stuck, you can make your partner a defendant in the lawsuit. The case caption would then be, you, plaintiff, jury consultant, and partner, defendants. In your complaint, you would explain that the partner was a necessary party who refused to join as a plaintiff. This ensures that the partner's interests are represented in court, even if they didn't want to sue, and that the judgment will be complete and binding on all parties. In essence, this rule gives the court the power to organize the parties in a way that allows for a complete resolution of the dispute, even when the parties don't all agree on the initial alignment. It's common for a plaintiff to accidentally include the wrong person or forget to include someone important in their lawsuit. Section 11 deals with these situations, misjoinder and non-joinder of parties. The rule starts with a very important principle. It explicitly states that neither misjoinder, meaning you joined a party incorrectly, nor non-joinder, meaning you failed to join a necessary party, is a ground for the dismissal of an action. In other words, these aren't deal breakers for the entire lawsuit. This is a very practical rule. Courts understand that initial pleadings might not be perfect. The purpose of a lawsuit is to resolve a dispute, not to be thrown out on a technicality. Instead of dismissal, the court has powerful tools to fix these mistakes. The rule says that parties may be dropped or added by order of the court at any stage of the action. This can be done if any party asks for it, or on the court's own initiative. Any claims against a party who is misjoined can be separated and dealt with in a different case. Let's revisit our bus crash scenario for an example of misjoinder. Suppose the injured passengers sue the bus company and, by mistake, they also sue Acme Road Construction, thinking that company was responsible for the road condition. Acme files a motion with the court, proving they had nothing to do with that road on that date. The court can simply issue an order dropping Acme Road Construction from the case. The case against the bus company proceeds without interruption. The entire lawsuit is not dismissed because of this single error. This rule promotes fairness and the efficient administration of justice. It ensures that honest mistakes don't derail a legitimate case. We've talked about joining a few parties, but what happens when the number of affected individuals is so large that it's impossible to join them all? That's where Section 12, the class suit, comes in. A class suit is a representative action where a small group of people sue or are sued on behalf of a much larger group that is similarly situated. For a class suit to be allowed, two main conditions must be met. First, the subject matter of the controversy must be of common or general interest to many people. This means everyone in the group has the same basic complaint. Second, the persons affected are so numerous that it is impracticable to join all as parties. Let's use an example. Imagine a large pharmaceutical company sells a drug that is later found to cause a severe side effect in thousands of patients. It would be impossible for all these thousands of patients to file individual lawsuits. In this situation, a class suit is appropriate. A few of the injured patients can represent the class of all patients harmed by the drug. They sue the company, and any judgment they win applies to the entire group. This rule serves several purposes. It gives people with small individual claims a way to seek justice when the cost of a private lawsuit would be too high. It also ensures that the courts aren't overwhelmed with thousands of identical cases, making the justice system more efficient. Finally, the rule allows any member of the class to intervene. If they feel their individual interest is not being adequately protected, they have the right to join the lawsuit and advocate for themselves. This is an important safeguard to protect the rights of all class members. So, to recap, a class suit is used when countless people share a common interest. It allows a few to represent many. This tool makes justice accessible and efficient, and is subject to court approval to ensure all interests are protected. Life is often uncertain, and sometimes even the plaintiff isn't sure who they are entitled to relief from. Section 13 addresses this with alternative defendants. This section allows a plaintiff who is uncertain against which of several persons they are entitled to relief to join any or all of them as defendants. This is allowed even if the right to relief against one defendant might be inconsistent with the right to relief against another. This rule is about allowing a plaintiff to cover their bases. Let's consider a scenario. You get into a car accident. You know the car that hit you is owned by John, but you're not sure if John was driving or if he lent his car to his friend Mark, or even if the car was stolen. You don't want to sue the wrong person because if you do, your entire case could be dismissed. Section 13 lets you sue both John and Mark as alternative defendants. Your complaint can state that the true responsible party is either John or Mark, but you're not sure which one. The court will then hear the evidence from both defendants to determine who is actually liable. This prevents the plaintiff from having to guess and risk losing their case. Now, let's look at another type of uncertainty. What if you know the responsible party exists, but you don't know their identity or their name? Section 14 covers this situation. This rule allows you to sue the defendant under a description. For example, you can sue the unknown owner of Lot 123 or heirs of deceased person. Once you discover the person's true identity or name during the legal process, you simply amend your complaint to name them properly. This rule is particularly helpful in situations involving property or estates, where ownership or heirship might not be immediately clear. It prevents you from being unable to enforce your rights simply because you lack identifying information. Finally, let's discuss Section 15, which deals with suing an entity without juridical personality as a defendant. This section covers situations where a group of people act together in a transaction but have not formally organized as a corporation or a partnership. The rule allows them to be sued under their common name. Think of a group of neighbors who decide to form a small club to share gardening tools. They call themselves the Green Thumbs Club and collect dues, but they never register as a formal entity with the government. Suppose they enter into a contract to buy new tools and then fail to pay. The seller can sue the Green Thumbs Club. This rule allows the club, as a group, to be brought into court. However, there's an important safeguard for the individuals in the group. The rule states that in their answer, the club must reveal the names and addresses of all the persons who compose it. This ensures that the individuals who are actually liable for the club's debts are identified. The final judgment would then be binding on these individuals. This rule prevents a group of individuals from escaping liability by operating under an informal name. To recap this rule, an unorganized group can be sued under its common name. The individuals behind the group must be identified in their defense to establish who is ultimately liable. This is a practical rule for dealing with informal groups and ensuring accountability. Finally, let's briefly touch upon other significant sections related to parties. Section 21 deals with indigent parties. It allows a person without sufficient funds for basic necessities to litigate as an indigent. This grants them an exemption from paying docket and other fees, ensuring that poverty doesn't bar them from seeking justice. The fees, however, become a lien on any favorable judgment they may receive. Section 22 mandates that the Solicitor General, the chief legal counsel for the government, must be notified in any action involving the validity of a treaty, law, or executive order. This ensures the government has the opportunity to defend its acts. Other sections, which we've not covered in detail here, deal with important procedural matters like substitution of parties when someone dies or becomes incapacitated. and transfer of interest during a lawsuit. These rules ensure that the composition of the parties in a case remains accurate and that the action can proceed fairly, even when circumstances change. Let's quickly summarize what we've learned about parties in civil actions. First, parties must be natural or juridical persons or legally authorized entities. The core principle is the real party and interest rule, which demands that the party who will be affected by the judgment must be the one suing or being sued, though representatives can act on behalf of others like minors or incapacitated persons. We also have special rules for spouses, minors, and other specific situations. We also explored how multiple parties can be brought into a single case through joinder. Permissive joinder is about convenience, allowing parties with a common question from the same transaction to litigate together. Compulsory joinder, on the other hand, is about necessity, requiring the presence of indispensable parties without whom the case cannot be fairly decided. And necessary parties, while not indispensable, are crucial for complete relief. Finally, we saw that the rules are designed to be practical. Misjoinder or non-joinder are not fatal errors. The court has the power to add or drop parties as needed. And in special cases, we have class suits for large groups and alternative defendants for situations of uncertainty. Mastering these concepts is crucial for navigating any civil lawsuit. You are now better equipped to understand who can participate in a legal dispute. Thank you for watching.